Hi, and thank you so much for joining us for Estate Planning for Families, COVID-19 Perspectives and Considerations. I'm Caitlin McAndrews from McAndrews, Mahalik, Connolly, Hulse, and Ryan, and joining me today is Lindsey Conan from Conan Law Offices. Lindsey, would you like to say a few words to introduce yourself?
Hi, sure. I'm Lindsey Conan, as Caitlin said. I have my own practice in media, but I also am of counsel with McAndrews Law Offices. So I'm excited to be here and excited to do my first presentation with you.
Yeah, I'm really excited to present with you too, Lindsey. Thanks so much for doing this. So to jump right in, because this will be a very brief look at some of the estate planning considerations that we're hearing from families now, and that we know families need to be considering during these difficult times. We're going to just jump right into what the fundamental estate planning documents are and what is typically included as part of an estate plan. And as we move through them, we'll talk about a few issues that may present themselves while we are dealing with this global pandemic. The first document, and what most people think of as the main part of an estate plan, is the will, which directs the disposition of your probate property. So one thing that we make sure to advise our clients of is the difference between probate property and non-probate property. Your will direct what happens to property that is part of your probate estate. What that does not include is anything that has a beneficiary designation, anything that is a transfer on death account or a joint account where it automatically transfers to someone else, or a trust that dictates the passage of property that's outside of your will. This is always an important document to have, but especially during uncertain health times, you want to make sure that you're directing your property to who you want to receive it. It's often said that either you write a will or the state does for you. Every state has its own intestacy laws that dictate who will get your property if you do not indicate what your intentions are. And a lot of our clients do not want their property to pass according to those intestacy laws, which are really just based on what family is closest to you in terms of lineal descendancy, but doesn't take into consideration friends, family, maybe minor children who are not prepared to inherit large amounts of money yet, or children with special needs who are going to rely on public benefits. It also allows you to indicate who you want to administer your estate, who's going to control the distribution and represent you in that process after you're gone.
Yeah, and another thing to point out is I have so many clients that say, I don't need a will, I don't have anything, and isn't my spouse going to get everything? And I think a lot of people don't understand that even if they don't have much, they have something that needs to be gifted to family, and that their surviving spouse does not inherit 100% of their assets upon death, and that their children would have to share with their spouse. So it's so important to have a will, and I think if you have $1 to your name, you really need a will. So the next thing that we should talk about is trusts, and trusts are a mechanism to hold property for somebody's benefit that we build into wills for our clients. And their trusts have different purposes. So the first trust that I want to address is the Credit Shelter Trust. And this is created to allow married couples to combine their individual unified credits to double the amount that they can pass tax-free to their children. So currently that amount that you can pass, that an individual can pass tax-free, federally tax-free, is $11,580,000, and per couple it's $23,160,000. So what it does is it allows those spouses to combine those credits so they can pass up to $23 million to their children free of federal estate tax. Obviously, they're still going to be taxed with Pennsylvania or whatever state they live in if there is a state tax. So the surviving spouse is generally the beneficiary of that trust during the lifetime, and then the residue would then pass to the children upon that surviving spouse's death. And typically the surviving spouse is the trustee of their own trust, so it allows them to have that control. It's just really a tactic to save as much money as possible for your children.
And the next trust we are going to talk about is a disclaimer trust, which is a very smooth transition from the credit shelter trust. This permits post-death tax planning. It's a good option when there are a lot of unknowns because it operates very similarly, except that the surviving spouse has to make a qualified disclaimer of property and then utilize the deceased spouse's federal or state tax exemption, depending on whether your state allows them. But in most respects, they operate very similarly to a credit shelter trust. The kind of considerations that I usually advise clients and when considering a disclaimer trust is whether they want that flexibility, but also if the surviving spouse is going to remember to contact an attorney right after the first spouse's death in order to make a proper disclaimer, because that's really important. Some people want that flexibility to be able to do the post-death tax planning, but you have to make sure that the surviving spouse will then either make a proper disclaimer themselves or consult an attorney in order to do so properly.
So important. The next trust is an ILIT, which is an irrevocable life insurance trust. And a lot of people don't understand that actually life insurance, while it's not taxable, it's included in that taxable number for federal estate tax purposes. So, a proper ILIT will remove the life insurance from the estate of the deceased policyholder and pass it to the children, and it does not count towards that asset limit for tax purposes.
A special needs trust is another important planning tool. And if you have been sitting here thinking, all right, this federal estate tax exemption is so far out of my reach that I don't need to consider a trust, you may want to focus in on the special needs trust because the amounts of money involved in planning with a special needs trust can be far smaller. The real important question here is, do you want to leave money to someone who may be relying on public benefits, specifically Medicaid or medical assistance and SSI? If you want to leave money to an individual, a family member or a friend who receives those public benefits, you do want to consider a special needs trust, which can allow them to benefit from the money that you're leaving them while also continuing to qualify for those public benefits. A full handling of special needs trust is beyond really the scope of this presentation, but one important thing to note is that there are a few different kinds of special needs trusts. One of them, the third-party funded special needs trust, will allow the beneficiary, the person with a disability, to receive those funds, and then the money can go to another intended beneficiary after their death. Whereas if they receive the money outright and then have to go put it into a special needs trust themselves, it's called a self-funded special needs trust. And there is a payback to Medicaid upon their death before it can go to any other beneficiaries. So for example, if you have 3 children and one of them has special needs and you want to leave money to them, but after their death, you want it to go to your other children or grandchildren or family members, it really is important to do proper foreplanning so that you can leave it into this third-party funded special needs trust. It never enters the name of your child with a disability, and then you're able to remember those other family members after without having to do a Medicaid payback first.
And the next and last trust that we have to talk about is the minors trust. And the minors trust really just provides a mechanism for you to provide for your minor children, and the assets would be maintained by the trustee on behalf of the minor children until they reach an age which you designate in your will. And at that age, there would be either an outright distribution to them, or they would start receiving smaller distributions. And that's something that you consult with your attorney about, so that you can structure the trust the way that you want it set up for the benefit of your children or grandchildren.
And we often say that a minors trust is somewhat of a misnomer because, as Lindsey said, it can be a designated age. And I know clients who want to distribute funds to their children at, 25, 45, even older than that. So you don't have to be a minor to have a minor's trust.
Correct.
The next documents that we're going to talk about are especially important during uncertain health times, and those are powers of attorney. A lot of people oftentimes don't think of these as part of their estate plan, and it really is a very crucial part, because your estate plan isn't just planning for when you're gone, it's planning for when you're not able to make or communicate decisions for yourself. Powers of attorney provide decision-making authority to an agent on your behalf, and typically we either see them as two documents or as one document encompassing two kinds of decision-making, which would be financial and medical decision-making, and authority to then make those decisions on behalf of someone. Financial powers of attorney can be drafted to be immediately effective, so it does not have to be used during a time of incapacity. But typically medical powers of attorney are only going to be used when you're not able to communicate decisions on your own behalf. I always say, if you're in the doctor's office and you're saying, don't give me that surgery, the doctor's not going to listen to your agent who may be contradicting you. That's obviously a joking situation, but you do want to pick an agent that you feel will make decisions in your best interest and that you believe will make the decisions that you would make on your own behalf. Obviously, this is important during any time because we never know what will happen, but especially as clients come to us with concerns about the current coronavirus and the, their own health concerns. This is an especially important document to make sure that you have and that your doctors have copies of as well.
And that leads us to the Advanced Medical Directive, and that really overlaps with that medical power of attorney. So as Caitlin mentioned, that power of attorney appoints an agent to make those decisions for you if you're unable to communicate them to your doctor yourself. And the Advanced Medical Directive really documents your wishes and instructions to medical providers regarding your end-of-life care. If you're unconscious and terminally ill with no reasonable hope of recovery, what is it that you want your doctors to know about your care? Do you want to be on a ventilator, which is really important in a time of COVID, when most people of advanced age, when they contract COVID, they end up on a ventilator, and that's a family decision that a lot of people are making. I've had calls from multiple clients who they've had to decide whether to put that family member on a ventilator. And if you don't have that Advanced Medical Directive, you're leaving that decision up to your family and to your spouse or to your children. And it's a lot easier and less of a burden for them if they know what you want. So, yeah.
So after covering all of these very crucial fundamental documents of an estate plan, we want to talk a little bit about why you may need an estate plan. We've highlighted some of these as we talked through the documents, but especially for those who do not have assets that are above the federal estate tax threshold, as Lindsey was talking about, people who come in and say, I don't have very much. On the will side of things, you do have something, as Lindsey said, and you want to make sure to direct the disposition of your property the way that you want it to occur, and not the way that the intestacy law would dictate. You also have an opportunity in your will to pick the administrator of your estate. Similarly to intestacy law, the law lays out an order of people who have the ability to qualify as your personal representative after you die if you don't have a will. And a number of people want to pick someone other than who the law would dictate. This gives you an opportunity to pick that person, to appoint them, and then to also talk with them and let them know that you are selecting them to fill this important role. It also allows you to guide distribution to minors or people with disabilities in a way that that is perhaps a little bit more carefully planned than if you were to just leave the money outright. So without an estate plan, you would not be leaving money in one of those minors' trusts or a special needs trust that we discussed earlier. Those documents are so important, as we mentioned before, to ensure that that a person who is reliant on public benefits will continue to receive those. It's also important for leaving money to minors or to young adults or even to older adults, because as we learn more and more about how the brain works, we learn that the prefrontal cortex that guides decision making and planning really isn't fully formed until your mid-20s. So a lot of people are not going to, even if they are legally adults, are not going to be in a good frame of mind to appropriately manage large sums of money if they inherit them outright at an age that is a little bit younger. Most of our clients are not wanting to leave money outright to their children at a younger age. And so, you can't do that kind of planning without an estate plan. On the other hand, there's also the powers of attorney documents and the advanced medical directive, which, as we discussed before, are not part of the will, but they are part of those fundamental estate planning documents. They are going to provide valuable authority to family members in the case of an emergency, and you wouldn't have them without it. There's no, it's not an automatic thing, the way that the intestacy law automatically directs the distribution of your estate if you don't have a will. So you do want to make sure that you've given your family members or loved ones proper authority to make decisions on your behalf in case of an emergency. And the other thing is that powers of attorney and advanced directives are very low-cost documents, and they can help avoid the need for your family to seek guardianship if you're not able to make and communicate decisions on your own behalf. Guardianship is a very expensive process, and unfortunately, we do see clients who have medical emergencies that then render them unable to make decisions for themselves. And if they don't have those authorities given to other people, then sometimes their family will need to seek guardianship in order to make those decisions for them, and that can be especially costly.
I think it's also important to note that, and this kind of segues into the next section, but the internet is not a place that you should be going to draft your estate plan. LegalZoom is only going to get you into trouble, or another internet company like that. Estate planning documents are extremely state specific, and they're not one size fits all, as we've discussed here today in this webinar, that there are so many different considerations, and a computer form and coding cannot really take all that stuff into consideration. So it's really important that you sit down with an attorney. And honestly, when it comes down to it, an attorney is not much more expensive than LegalZoom. So that segues into our next segment. What information does an attorney need from you to do a proper estate plan? So obviously the straightforward stuff: names, addresses, dates of birth, and family members. General asset information. So yeah, cash in the bank, IRAs, 401ks, pension plans, life insurance is extremely important, especially if there may be an ILIT in consideration. So information on life insurance, the beneficiaries of those life insurance plans. Many times when I ask my clients who's the beneficiary of a policy, they cannot remember. So it's always a good thing, even if you're not making any changes, it kind of reminds clients to just take a look at those policies and make sure that the beneficiary is who you want it to be. And then a distribution plan. So what are your intentions? Do you want everything to go to your spouse and then to your children? Do you want grandchildren included? That sort of a thing. If you have some minors that are potentially inheriting, who do you want to be in charge of trusts for them if there's going to be a trust? If you have minor children, who are going to be the guardians for those children if both you and your spouse pass away? So there's all those things that really need to be considered, and McAndrews' office does have an excellent estate planning questionnaire that you can fill out in advance of your appointment. Is that on the website? I think it is on the website. It is.
Yeah.
It's available on the website, and you can download it and fill it out to get ready for your appointment.
Finally, we want to talk a little bit about how to choose an estate planning attorney, whether that be one of us or someone else. The estate planning attorney that you choose, you want to make sure that you feel comfortable with discussing all of these very difficult decisions with them. A lot of clients come in knowing that they need an estate plan, but they don't want to think about what will happen to their kids after they're gone, or what will happen to them if they have a medical emergency or need long-term care of any sort. And so these are difficult conversations and difficult decisions to make. And I think it takes a lot to just make the appointment. So we want to talk a little bit about how you can choose that estate planning attorney that you're going to feel comfortable going through this process with. As with many other professionals that you may select, you want to ask about their credentials and their experience to see if they have any memberships in organizations such as the National Academy of Elder Law Attorneys or other entities that have continuing legal education opportunities for attorneys that allow for greater experience and networking, because a lot of these memberships allow for attorneys to grow in their own practice and to gain greater experience in these questions that you're going to be discussing with them. As with a lot of professionals, you want to check out their website, see if there are any articles that help you to understand the process that you're going to be embarking down, or answer any questions that you may have before you begin the process. You can ask about their continuing education. And as I mentioned, a lot of the membership organizations for estate planning attorneys, such as NALA, have opportunities for continuing education, opportunities for networking, listservs where attorneys are constantly improving upon their understanding and experience in these areas. And then also look for public speaking engagements that attorneys do, because you can get a feel for their knowledge, their experience in the area, for their personalities, and whether you think that it would be a good fit, because ultimately you really do have to feel comfortable speaking with your attorney about a lot of these very difficult questions. We finally just wanted to end with this quote that estate planning is an important and everlasting gift you can give your family. As you're discussing these questions with your family and thinking through them yourself, we want you to understand that not only is estate planning an important process to go down, but it's also very important to your family and very helpful to your family to engage in these conversations, these decisions and discussions now.
It's also important that once you have an estate plan in place, you should probably talk with your children and your family about it so that they understand what to expect, who's going to be the power of attorney, and who's in charge of medical decisions, so that they're not clueless. And it really is a gift that you can give your family to just be properly prepared.
Thank you so much for joining us today. Please don't hesitate to reach out to either of us through our website for additional questions and to get a questionnaire and possibly schedule an appointment.
Thank you, Caitlin.
Thank you, Lindsay. Okay, I think Allie can just edit the front